A very interesting question has been asked whether a company whose name has been struck off from the register maintained by the Registrar of Companies under Section 248 of the Companies Act, whether this company can be hauled to corporate insolvency resolution proceedings under Section 7 and Section 9 of the Insolvency and Bankruptcy Code 2016. Now, we know that Section 7 of the IBC talks about the hauling of the corporate debtor by the financial creditor into insolvency proceedings, and Section 9 of the IBC talks about hauling the corporate debtor into corporate insolvency resolution proceedings by the operational creditor. Now, this question was answered in this judgment, Electrans Shipping versus Pierre de Silva. Let's look at the facts of the case. Now, Pierre de Silva was an operational creditor of Electrans Shipping. Pierre de Silva hauled the company to insolvency proceedings under Section 9 of the IBC. On the 10th of April, the Mumbai bench of the NCLT admitted Electrans Shipping into insolvency proceedings. Obviously, the company challenged this order of the NCLT and the matter moved to the NCLAT. Now, what did Electrans Shipping argue in the NCLAT? It said that its name was struck off from the register maintained by the Registrar of Companies on 12th September 2018. So the NCLT ought to have considered the fact that its name had been struck off by the registrar and therefore dissolved, and therefore no suit could be maintained against it under Section 7 and Section 9 of the IBC. Now, Section 248 of the Companies Act talks about the removal of the name of the companies from the Register of Companies. The registrar is empowered to remove the name of companies from the register maintained by him. What did the NCLAT hold? The NCLAT held that yes, a company whose name has been struck off from the register maintained by the Registrar of Companies can be hauled into CIRP proceedings under Section 7 and Section 9 of the IBC. And how do you do it? You do it by reading Sections 250 of the Companies Act along with Sections 248 subsection 7 and subsection 8 of the Companies Act 2013. What does Section 250 of the Companies Act state? It says that a company who has been dissolved under Section 248 shall, on and from the date of dissolution mentioned in the notice under subsection 5 of Section 248, it shall cease to operate as a company, number 1, and 2, the certificate of incorporation shall stand cancelled from that date. Except, there is an exception out here, except when that company has obligations to pay, it has obligations to fulfill, it has dues to be paid, then the company will not be treated as being dissolved. This is what Section 250 of the Companies Act 2013 says. Section 248 subsection 7 of the Companies Act states that the liability of every director, manager, any other officer who was exercising any power of management and every member of the dissolved company shall continue, the company shall continue, their liability shall continue and will be enforced as if the company has not been dissolved. Section 248 subsection 8 of the Companies Act talks about the power of the tribunal to wind up the company. Now, if the name of the company has been struck off from the register maintained by the Registrar of Companies, then the tribunal has the power to wind up that company. Now, if the tribunal has the power to wind up the company whose name has been struck off from the register, obviously the hauling of that company, which is before the liquidation of that company, can be permitted, and therefore, under, even though a company has been the company's name has been struck off from the register maintained by the Registrar of Companies, proceedings under Section 7 and Section 9 of the IBC will lie against such a company.